All right, welcome to another deep dive. Today we're taking a look at something you might not think is too exciting at first glance. Contract law.
Yeah, not exactly the stuff of blockbuster movies, right?
Right. But believe it or not, there's a whole world of philosophical questions lurking beneath those seemingly dry legal agreements. You sent us the Stanford Encyclopedia of Philosophy entry on philosophy of contract law, and we're going to see what we can unpack from it.
It's actually pretty fascinating stuff when you start to dig in. Like, what makes a simple agreement to buy or sell something legally binding? And what happens when someone breaks their word? These questions get to the heart of how we interact with each other in a society, especially when it comes to economic exchanges.
Yeah, it's not just about the legal technicalities. It's about fairness, freedom, and the moral underpinnings of our promises and commitments. So where do we even begin with something as broad as the philosophy of contract law?
Well, the Stanford Encyclopedia entry lays out a few different ways philosophers have tried to understand what contract law is all about, like what its core purpose is. But before we get into those different theories, let's just start with the basics.
Okay, sounds good. Back to square one.
Right, so at its most fundamental level, contract law deals with these voluntary legal obligations that come about when we make choices. Like when you offer to do something and I accept that offer.
Like agreeing on a price for that vintage guitar you're selling.
Exactly. So the basic building blocks are these voluntary actions we take, and from those actions, legal obligations are born. But then the big philosophical question is, why should the legal system even care about these voluntary agreements?
Right. Why not just leave it up to individuals to sort things out if a deal goes sour?
That's where those general theories of contract law come in. Each one tries to offer a different answer to that why question.
So what's the first theory on the list?
Well, one of the most influential is the idea of contract as promise. The basic idea here is that in our personal lives, we generally feel a moral obligation to keep our promises, right?
Yeah, most of us would say breaking a promise is wrong, even if it's just a promise to help a friend move or something.
Right. So this theory, which was really championed by legal scholar Charles Fried in his book Contract as Promise, says that contract law is essentially the state stepping in to enforce that same basic moral duty, but in the context of agreements with legal consequences. It's like saying that a contract is just a special kind of promise that the legal system backs up.
So if I promise to sell you my car for a certain amount, contract law gets involved because it sees that as a similar kind of commitment as a personal promise, just in a more formal legal setting.
Exactly. And the way courts handle breaches of contract kind of supports this view, too. Like the typical remedy is what's called expectation damages.
So it's not just about making the harmed party whole again.
Right. It's about trying to put them in the same position they would have been in if the promise had been kept. Let's say we have a deal for me to sell you that car for $5,000, and then I back out. The law, under this contract as promise view, wants to get you the value of what you expected from the deal, not just cover any expenses you had because you relied on my promise.
Okay, so expectation damages sort of reinforce the idea that it was the promise itself that was broken and needs to be remedied, not just any harm caused by relying on the promise.
Exactly. Plus, contract law generally operates under strict liability, meaning I'm responsible for breaching the contract even if I had what I thought was a really good reason. It's like saying the promise itself carries the weight.
That seems like a pretty straightforward theory, but I'm sure there's some holes in it, right?
Yeah.
I mean, not all promises are created equal.
Oh, absolutely. There are definitely some challenges to this contract as promise idea. Like one big one is, why should the government use its coercive power to enforce what seems like a personal moral obligation?
Right, like why get the law involved in something that seems like a matter of personal ethics?
Exactly. Some argue that in a free society, the legal system should be more concerned with protecting our basic rights and liberties than with forcing people to be morally virtuous.
And then there's that age-old philosophical question of whether there really is a duty to keep every single promise, no matter how trivial.
Right, like is there really a bare reason to keep a promise, even if no one relied on it and no harm comes from breaking it? It's a tricky philosophical question. And practically speaking, if I promise to, I don't know, organize all the books in my library alphabetically and then I don't do it, is that something the law should get involved in?
Probably not. It seems like some promises carry more weight than others,
Mm.
and contract law might be more about those more substantial promises that have real-world consequences.
Right. And on top of that, even the rules of contract law don't always line up perfectly with this idea of simply enforcing promises.
Like what? What are some examples?
Well, take the concept of consideration. In most cases, for a promise to be legally enforceable as a contract, there needs to be a bargain, a kind of mutual exchange of something of value.
So I promise to sell you my car, and you promise to pay me $5,000. There's an exchange there.
Exactly. But in the realm of pure morality, even a promise where one person isn't getting anything tangible in return, what we call a gratuitous promise, can still create a moral obligation.
Like promising to give a friend a gift. You're not getting anything back, but you might still feel morally bound to follow through.
Right. But the law is generally pickier about which promises it will enforce. There are exceptions, of course, like situations where someone relied to their detriment on a promise, even without formal consideration. But the general rule is that you need this element of exchange.
Interesting. It seems like the contract as promise theory is a good starting point, but there are definitely some wrinkles when you look at the specifics of contract law and how it actually operates.
Definitely. And that leads us to another major theory, which focuses less on the promise itself and more on the harm that can be caused when a promise is broken. This view sees contract law as being about the duty not to harm and protecting the promisee's reliance interest.
Okay, so this is more about the negative impact on the person who is counting on that promise being kept. It's not about the broken promise itself. It's about the disappointment and the practical setbacks that can happen.
Precisely. Philosophers like T.M. Scanlon argue that contract law is fundamentally connected to this broader moral principle of not harming others. If I promise to sell you that car, and you reasonably rely on that promise, maybe you sell your old car or make plans based on that expectation, then me breaking that promise causes you real harm. Scanlon even proposes a principle of fidelity, which basically says that when you give someone an assurance, you create a moral obligation not to let them down, especially if they act on that assurance.
So it's almost like a ripple effect. The broken promise doesn't just exist in isolation. It has consequences for the person who is relying on it.
Exactly. It disrupts their plans, maybe causes them financial loss, and definitely erodes trust. And this theory sees contract law as a way to address those harms. In a way, it sees contract law as being similar to tort law.
Tort law, like when someone's negligence causes harm to another person.
Right. Both are about trying to prevent or remedy wrongful harms that people cause through their actions. But even this harm-based view of contract law runs into some puzzles.
Like what? What doesn't quite fit?
Well, if the main goal is to prevent harm caused by reliance on a broken promise, you'd think the focus would be on what are called reliance damages.
Which would just compensate the person for the specific costs they incurred because they relied on the promise,
Yeah,
right?
exactly. But remember how we talked about expectation damages being the standard remedy in contract law?
Right. It's about giving the person the full value of what they were expecting from the deal, not just covering their specific costs.
Exactly. So there's this tension between the harm-based theory and the way contract law actually operates. If it's all about preventing harm from broken promises, why not just focus on those specific harms caused by reliance? Why go above and beyond to give the person the full benefit they were expecting?
Right. That does seem a bit odd. I guess one could argue that protecting expectations in the long run leads to more trust and better planning, which ultimately reduces harm. But it's still a bit of a mismatch between the theory and the practice.
It is, and there's another tricky thing about this harm-based view. It often relies on the idea of reasonable reliance. Like, to trigger this obligation not to harm, the person relying on the promise has to have been reasonable in doing so.
Which kind of seems circular, right? You're saying you have a duty not to break a promise because it's reasonable for people to rely on promises. But what makes that reliance reasonable in the first place? Is it because you have a duty not to break the promise?
Right.
It's a bit of a chicken and egg situation.
It is. And to make things even more complicated, sometimes contract law doesn't even seem to require this reasonable reliance at all.
So even if you had reason to doubt that I'd follow through on my promise, I could still be held accountable.
Potentially, yes. Like, let's say I promise to sell you my car, and I give you a very specific guarantee about its condition, but that guarantee turns out to be false. Even if you had your doubts about my honesty, I could still be held liable for breaching that guarantee. There are also situations like when someone warns you in advance that they're going to breach a contract, where contract law still seems to prioritize upholding the original agreement, even if the non-breaching party could have taken steps to mitigate their potential harm.
So it seems like this duty not to harm view adds another layer to our understanding of contract law. But like the contract as promise theory, it doesn't perfectly capture everything about how contract law functions in the real world.
Exactly. It's a piece of the puzzle, but not the whole picture. So that brings us to a third major approach, which is a bit more pragmatic, and that's the economic view of contract law.
Okay, so this one is less about morality and more about the practicalities of exchange.
Precisely. This view argues that the main point of contract law is to enable mutually beneficial exchanges and to make those exchanges as efficient as possible. It's not so much about enforcing promises or preventing harm, but about creating a stable and predictable framework that lets people confidently enter into agreements, invest in those agreements, and ultimately generate more economic well-being for society as a whole.
It's about keeping the wheels of commerce turning smoothly.
Exactly. A long time ago, the philosopher David Hume talked about how crucial security and trust are for a society to flourish. And from this economic perspective, that's what contract law provides. It gives people the confidence to make deals, knowing that the legal system will back them up if things go wrong. It's almost like a well-oiled machine for facilitating exchange and generating wealth.
Okay, so this view is all about creating the optimal conditions for people to make deals and rely on those deals, leading to a more prosperous society overall.
Precisely. And this economic perspective can lead to some interesting critiques of traditional contract law doctrines. For example, if you're really committed to maximizing efficiency, you might question why we have all these formal requirements, like consideration. If a promise clearly led someone to make investments or take actions that benefit everyone involved, why get hung up on whether there was a technical exchange of value?
Right, it seems like this view would be more flexible about the specifics of the agreement as long as the overall outcome is a net positive.
Exactly. And it might even be more open to the idea of efficient breach, which we touched on earlier.
Which is the idea that breaking a contract can actually be a good thing if it leads to a much better outcome for everyone involved, even if it means going back on your word.
Right. Like if I'm contractually obligated to sell you a piece of land for $10,000, but then someone else comes along and offers me $100,000 for it, it might make more economic sense for me to break the original contract, pay you some damages, and sell it to the higher bidder.
From a purely economic standpoint, that does seem more efficient, even if it feels a bit morally icky to break a promise.
Yeah, it definitely highlights the potential tension between economic efficiency and our moral intuitions about keeping our word. But even this economic approach isn't without its puzzles. Like, if efficiency is the ultimate goal, why doesn't contract law more often force people to fulfill their contracts exactly as written through what's called specific performance?
Right, why not just make people follow through on the exact terms they agreed to no matter what? Wouldn't that be the most efficient way to ensure that contracts are taken seriously?
It seems that way on the surface, but there are economic arguments against that too. Forcing specific performance in every case could actually prevent even more beneficial deals from happening down the line, or it could create opportunities for one party to hold out and demand more than their fair share, leading to a kind of inefficient haggling.
So even within this economic framework, there are these complex trade-offs and considerations about how to best achieve the goal of maximizing efficiency.
Exactly. And another critique of this economic view is that it tends to focus more on businesses and large organizations, where individual freedom and autonomy might not be as central as they are in contracts between individuals.
Like when you're dealing with a massive corporation, it's not like they're going to be emotionally harmed by a breach of contract in the same way a person might be.
Right, and economic analyses often use these simplified models where they assume everyone is a perfectly rational, self-interested actor. That might make sense for a company trying to maximize profits, but it doesn't always capture the complexities of human motivation, especially when we're talking about individual people entering into contracts.
So it's not necessarily wrong, it's just a limited perspective that might not be appropriate for all types of contracts or all types of parties.
Exactly. Plus, even the way this economic approach defines welfare can be tricky. It often boils down to things like preference satisfaction and willingness to pay, which can be influenced by existing inequalities. Someone with more money might be willing to pay more for something, skewing what appears to be the most efficient outcome.
Right, it's like saying the person with the biggest wallet always gets what they want, which doesn't necessarily seem fair.
Exactly. And some philosophers, like Ronald Dworkin, have argued that courts should be more concerned with upholding individual rights and principles of fairness than simply trying to maximize some abstract measure of overall welfare.
So again, it seems like we found another piece of the puzzle, but not the whole thing.
Right. And that brings us to a fourth approach, which focuses on the normativity of the contract relation itself.
Okay, so what does that mean? The normativity of the contract relation.
This view is kind of saying that contract law isn't just about enforcing pre-existing moral duties or creating economic efficiency. It's about the special kind of relationship that is created when people enter into a contract.
So the agreement itself creates a unique bond between the people involved.
Exactly. Thinkers like Joseph Raz have argued that promising, and by extension, contracting, has this unique power to create obligations between people, almost like generating a moral connection. And this view sees contract law as being about recognizing and upholding that special connection.
So it's not just about the words on the page, it's about the shared understanding and commitment that comes from the act of agreeing.
Precisely. And one aspect of this is what's called the theory of relational contracting. This theory emphasizes how contracts often exist within a broader web of social and commercial relationships. The idea is that the norms and customs that govern those relationships, like trust and reciprocity, can actually be more important in explaining why people keep their contracts than the formal legal rules themselves.
It's like saying that contracts are more than just isolated transactions, they're embedded in these ongoing relationships.
Exactly. But other theories within this approach focus more on the formal legal relationship itself, the one that's created by the contract. They look at how the parties are intentionally directing their actions and communications toward each other, and how the contract establishes a kind of shared framework for their interaction.
It almost sounds like the contract creates this little temporary community with its own rules and expectations.
It kind of does, and some philosophers, drawing on the ideas of Immanuel Kant, even see contracts as a way of creating a shared perspective, a kind of united choice between the parties.
Okay, so how do these relational theories explain why we should keep our contracts? Where does the obligation come from?
Well, they often see the value of contract in this shared perspective, this mutual recognition of each other as agents capable of making and keeping commitments. And the legal requirement of good faith that we see in contract law can be seen as reflecting this idea. Like, you're not just supposed to follow the letter of the contract. You're supposed to act in a way that respects the spirit of cooperation and trust that underlies the agreement.
And what about the concept of consideration, that requirement of mutual exchange? It seemed a bit awkward when we were talking about contract as promise.
Yeah, but it fits in really well with these relational theories. The exchange of consideration can be seen as a tangible sign that the parties have created this new relational unit, that they've both contributed to the formation of this shared commitment.
Okay, but I'm thinking about all those situations where people enter into contracts for purely self-interested reasons. Like, I might agree to buy your guitar just because I want the guitar, not because I care about our relationship or some grand moral principle. Doesn't that kind of undermine this whole special relationship idea?
It's a good point. If we're only keeping our contracts because we're afraid of getting sued or because it serves our narrow self-interest, then yeah, it does raise questions about the genuineness of that special relationship these theories are talking about.
Right, it seems like the law's involvement might even get in the way of the kind of genuine trust and reciprocity these theories value. Like, if I know you're only keeping your promise because you're afraid of getting sued, it doesn't exactly inspire warm feelings of trust.
That's one of the worries. There's this idea that the law might crowd out more desirable intrinsic motivations for cooperation.
And what about those huge contracts between corporations where it's not really about interpersonal relationships at all?
Yeah, these relational theories sometimes struggle to account for those situations. Like, if it's a contract between two faceless corporations, where's the special relationship?
It seems like, once again, we found a theory that sheds light on some aspects of contract law, but maybe not all of them.
Right. And that takes us to our final approach, which is actually not so much a theory, but more of an acknowledgement that maybe there isn't one single overarching explanation for contract law. This is the idea of pluralism.
Pluralism, like recognizing that there are many different valid perspectives on what contract law is about.
Exactly. Pluralism suggests that contract law isn't driven by just one principle, but rather by a whole bunch of different values and goals that are all kind of intertwined. It's like recognizing that there are good reasons to enforce promises, to prevent harm, to promote economic efficiency, and to value the relational aspect of contracts. And that all of these things are playing a role in how contract law actually works.
So it's less about finding the one right answer and more about accepting that there are many different factors at play, maybe even some that are in tension with each other.
Exactly. And this idea of pluralism often comes about when people realize that no single theory can perfectly explain all the complexities and nuances of contract law. But then the big challenge for pluralism is to figure out how all these different commitments are integrated. Like, is there some underlying covering value that helps us decide which goal to prioritize when they conflict? Or are we just kind of muddling through with judges making decisions on a case-by-case basis, trying to balance these different values as best they can?
It sounds like pluralism embraces the messiness of the real world and think out that there might not be one neat and tidy answer to the question of what contract law is really all about.
It does. And it leaves room for ongoing debate and refinement as we grapple with new challenges and changing social contexts.
Okay, so we've explored all these different ways of thinking about contract law as a whole. But the Stanford Encyclopedia entry also goes into some specific philosophical themes that come up within contract law.
It does, and these themes draw insights from other branches of philosophy, like philosophy of language, philosophy of action, and even moral and political philosophy. Like, one big one that we've already touched on a bit is the issue of language, meaning, and interpretation.
Which makes sense. Contracts are basically made of words, so how we understand those words is absolutely essential.
It is. And contract law has to grapple with this fundamental question of how to translate the words that people use into concrete, legally binding obligations. One key distinction that we've talked about a bit is the difference between objective and subjective meaning.
Right, objective, meaning being what a reasonable person would understand the words to mean, regardless of what the parties secretly intended in their own heads.
Exactly. And in most legal systems, contract law tends to prioritize that objective meaning. Like, there's this famous case, Hotchkiss v. National City Bank, where the judge basically said that the individual personal intentions of the parties aren't really relevant when it comes to interpreting a contract.
So even if I'm secretly thinking one thing when I make an offer, if a reasonable person would understand my words to mean something else, I could be stuck with that other meaning.
That's the basic idea. It's about having a clear, publicly accessible standard for interpreting agreements, rather than trying to delve into the murky depths of people's unexpressed thoughts. And this preference for objective meaning also shows up in other legal rules.
Like what? What are some examples?
Well, there's the parole evidence rule, which generally says that if you have a written agreement, courts won't consider evidence of prior agreements or conversations that contradict what's in writing.
It's like saying the written contract is the final word.
Exactly. And many contracts even include clauses that specifically dictate how the contract should be interpreted, further reinforcing this idea that the written words are paramount.
It's all about trying to create certainty and predictability, which makes sense in a legal context. But what happens when the words themselves are ambiguous or open to interpretation? Isn't that where things get tricky?
It is, and that's where this debate between textualism and contextualism comes in.
Okay, I've heard those terms thrown around, but I'm not exactly sure what they mean in the context of contract law.
Well, textualists argue that when you're trying to figure out what a contract means, you should stick to the plain, objective meaning of the words in the written document. Don't bring in a lot of outside evidence or try to read between the lines.
So textualists are kind of like strict grammarians. They want to stick to the literal meaning of the text.
You could think of it that way. They worry that allowing too much consideration of outside context could lead to judges essentially rewriting the contract, which would undermine the whole point of having a written agreement in the first place.
And then contextualists are the opposite. They think the words themselves aren't enough to understand the true meaning of a contract.
Exactly. They argue that you have to look at the broader context in which the agreement was made to really understand what the parties meant. Like, what were their prior dealings? What was the purpose of the contract? What were the circumstances surrounding its formation? They think that ignoring all of that can lead to misinterpretations and unfair outcomes.
It seems like both sides have a point, though. You want the contract to be clear, but you also want to make sure it's being interpreted in a way that reflects what the parties were actually trying to accomplish.
It's a tough balance. And one philosopher, Gideon Rosen, offers a helpful distinction between what he calls semantic intentions and pragmatic or legal intentions. Semantic intentions are about what you intend your words to mean, while pragmatic legal intentions are about what legal effects you intend to create with those words.
So I might use a certain word thinking it means one thing, but legally, it might have a different meaning or consequence.
Exactly. And there's this case in Rhys estate that illustrates this really well. A man left his property to his wife, but it turned out he wasn't legally married to the woman he was living with, even though he thought he was. So the court had to figure out, did he mean wife in the strictly legal sense, or did he mean the person he considered his wife, even if they weren't officially married?
I could see how that would cause some legal headaches.
Definitely. And contract law, while it generally favors objective meaning, is ultimately interested in figuring out the parties' legal intentions, which are sometimes different from the literal meaning of the words they used. So this whole textualist, contextualist debate can also be seen as a debate about whether we should prioritize the cold, hard meaning of the words or the underlying intentions of the parties, and about how much outside evidence we should consider in making that judgment.
It's fascinating how even just thinking about the language of contracts can lead to all these complex philosophical questions.
It really does. And on top of that, there's the simple fact that language itself is inherently ambiguous and prone to misunderstandings. The Stanford Encyclopedia entry has a whole section on different kinds of linguistic ambiguities that can cause contract disputes. Like you have homonymy, which is when the same word can have multiple meanings. There's this classic case, Raffles v. Wishelhouse, where the parties thought they were talking about the same ship, but there were actually two ships with the same names sailing at different times, leading to a big mess.
So it wasn't just a miscommunication, it was like a linguistic trapdoor.
Exactly. Then you have cases where a word itself has multiple possible meanings, like in Frigilamin importing v. BNS, which was a dispute over what exactly constituted chicken. And you can also have ambiguities based on the grammatical structure of a sentence, or ambiguities that arise because the meaning of a word depends on the context of the conversation. And then there's just the simple fact that some words are inherently vague, like reasonable or substantial. Trying to pin down what those terms mean in a specific context can be a nightmare.
It's like the English language is a minefield for contract lawyers.
In a way, it is. It just highlights how crucial careful drafting and interpretation are in contract law.
Okay, let's shift gears to another big philosophical theme. Freedom and autonomy in contract. We often hear about the importance of voluntary exchange between autonomous individuals, and that seems like a cornerstone of contract law.
It absolutely is. The basic assumption in contract law is that when people enter into agreements, they're doing so freely and with a clear understanding of what they're getting into. That's why there are legal protections against things like fraud, duress, and undue influence, which all undermine that idea of free and informed consent.
Right, it's like saying that a contract isn't truly valid if one party was tricked or coerced into it.
Exactly. But then the question becomes, why is this principle of freedom and autonomy so important in the first place? Like, you can imagine a legal system that focuses more on achieving good outcomes, even if it means setting aside the question of whether the parties truly consented to the agreement.
Like a benevolent dictator who forces everyone to make the right choices even if they don't want to.
Right. But that kind of system feels inherently unjust, even if it leads to what we might consider good results.
It seems like there's something deeply important about allowing people to make their own choices, even if those choices aren't always perfect.
Exactly. And there are several reasons why this idea of voluntariness is so central to contract law. For one thing, it's thought to promote individual well-being by giving people the power to shape their own lives and pursue their own goals. It also aligns with the idea of promissory obligation, because a promise made freely carries more moral weight than a promise extracted under duress. And it helps to avoid unfairly imposing obligations on people who didn't have a genuine opportunity to say no.
So it's about respect for individuals and their capacity to make their own decisions. But contract law doesn't just blindly assume that everyone is capable of entering into contracts. There are rules about capacity, right?
Absolutely. To be legally capable of entering into a contract, you generally need to have the ability to understand what you're agreeing to and the ability to make choices freely. This is where issues of mental competence, intoxication, and age come into play.
So a young child or someone who's severely intoxicated might not be considered capable of entering into a valid contract.
Exactly. And then there are all these other factors that can undermine freedom of contract, like a lack of information or coercion through threats.
Like if you're selling me a house and you fail to disclose a major problem, like a leaky roof, that could be considered a form of fraud because I'm not making my decision with full knowledge of the facts.
Right. And the law has to draw lines about how much disclosure is required. Like, do you have to reveal every single little detail or just the really important stuff? There's a whole philosophical debate about where that line should be drawn. And then there's the tricky issue of duress.
Which is when someone forces you into a contract against your will.
Right. Right. But it's not always clear cut. The law distinguishes between physical duress, which is pretty straightforward, and duress through threats, which can be a lot more subtle. Like, if I threaten to fire you from your job unless you agree to sell me your car at a ridiculously low price, that could be considered duress, even though I'm not physically forcing you to do anything.
It's like I'm exploiting your vulnerable position to get what I want.
Exactly. And the general legal standard is that a threat is considered wrongful if the person being threatened has no reasonable alternative but to give in. But then, of course, there's the whole question of what counts as a reasonable alternative, and that's something philosophers have debated endlessly.
And what about those situations where maybe there's no outright threat, but one party has so much more power or resources that the other party feels like they have no choice but to agree?
That gets into the realm of undue influence, which is when someone uses their position of power or trust to pressure someone into a contract that's not in their best interest.
It's like a subtle form of coercion.
It is. And then there are all those psychological factors that can influence our decision-making, like cognitive biases and emotional pressures, which the law doesn't really address directly.
Like if I'm desperate for money, I might agree to a contract that I wouldn't agree to under normal circumstances.
Exactly. So this whole idea of freedom and autonomy in contract is a lot more complicated than it might seem at first glance. It's not just about the absence of physical force or explicit threats. It's about ensuring that people have a genuine opportunity to make choices that are in their best interests without being unduly influenced or pressured.
Okay, let's move on to another fascinating topic.
Mm.
Intentionality in contract law. We talk about contracts being based on a meeting of the minds, but what does that even mean in today's world of click-through agreements and those endless terms and conditions we never read?
Yeah, that's a huge challenge to the traditional way of thinking about contracts. Like, if I click, I agree to a 100-page terms of service agreement without reading a single word, can we really say I intended to be bound by all those terms?
It feels more like a forced march than a genuine agreement.
It does, and it raises questions about what role intention actually plays in these kinds of mass market contracts. Like, the law distinguishes between formal agreements and what are called quasi-contracts, where obligations are imposed even without a clear agreement. A classic example is emergency medical care. If you're unconscious and I save your life, you're probably going to be obligated to pay me for my services, even though we never had a chance to shake hands and make a deal.
It's like the law assumes you would have agreed if you'd been able to.
Exactly. But standard form contracts, even those ridiculous online ones, are still treated as real agreements. The argument is that by clicking I agree, you're expressing a general intention to be bound by the terms even if you haven't read them in detail. But the level of understanding and deliberation in those cases is so different from, say, negotiating a contract face to face.
Right. It's not like I'm carefully considering each clause and its implications. It's more like a surrender to the inevitable.
It is. And when we look at the philosophy of action, which tries to understand what intention really is, it gets even more complicated. Some philosophers see intention as being about beliefs, desires, and plans, like if I intend to.